The main objective of this seminar is to answer some relevant questions on this matter that are required for the debates and analysis that we are conducting now in Chile, and also that we can learn from west of the United States experience. Some of these questions are, what are the limitations imposed by water law in the transition to a more sustainable management of water resources, both in Western US and Chile? What are the commercial and non-commercial mechanisms for reserving water for fresh ecosystems? And associated with that, how do legal, institutional, or regulatory characteristics generate segmented water markets, both in Chile and in California? Our seminar is broken into 4 sessions that will deal and try to generate debate and discussion on these previous questions. The first session is a comparative analysis of water law in US, the west of the US, and Chile, concentrating on limits to private property. This afternoon, we have session 2, which will look at future challenges in water law and water markets, looking at environmental water management. On Thursday, we have our 3rd and 4th session, the 3rd one comparing water markets in Chile and California, and our 4th session looking at water and the Chilean Constitutional Convention that has recently started. This seminar has been organized by Universidad del Desarrollo with collaboration of Universidad Mayor, Arizona State University, Center for Environmental Economics and Sustainable Policy, Stanford, Water in the West, Center for Climate and Resilience Research, CR2, CRIAM, Centro de Derecho UC en Derecho y Gestión de Aguas, Water Law and Management Center of the Catholic University, and CAPES, Center for Applied Ecology and Sustainability, also of the Catholic University. So to start, we will have the presentations of our 3 speakers. Then we will answer your questions in the final section of this session. Questions and answers, the chat is open, the box is open as of now, so you can start posing your questions, which we will look at in the end. We will start our session with a presentation by Paul Kibble, Professor of Law, Co-Director of LLM Environmental Law. And Paul, you have 40 minutes for your presentation.
Thank you. So thank you, Guillermo and Jorge and Michael Hanneman and all the other organizers of this event for the invitation and opportunity to speak. What I'm going to try to do, and I think Camila as well a little bit, is to help set up some of the more comparative Chile-US themes of the conference that will follow. And I was asked to sort of provide an overview of sort of, major themes in California water law that relate to the subject of the conference. And I'm going to try to do this in around 30 minutes. I realize I have 40, but I want to leave time for discussion. So in consultation with the organizers, in particular with Camila, I'm going to focus on 3 particular aspects of California water law, which I liked because they all begin with the letter O. But the 3 groupings that I have organized are the aspect of over-allocation of surface waters and rivers, opportunities to address this overallocation and obstacles in addressing this allocation. At the outset, I will sort of share that the perspective that I bring to this is there's sort of two perspectives. One is that of a water law professor and scholar. I've been teaching in the area of water law for about 12 years now and publish in this area. But the other is that I was before, and I remain a practicing water rights and fisheries lawyer here in California. I work for a firm in Berkeley called Water and Power Law Group that specializes in water, fisheries, and hydropower related issues in the United States, not just California. So this might come out more in the discussion afterwards, but I'm bringing my perspective as a practitioner as well as an academic. And the final thing that I will add, Guillermo sort of suggested, which may have been the origins of the conference, that the idea was to help inform debates that are going on in Chile about possible changes to their constitution related to water. And I wish all of my Chilean colleagues and the Chilean people that the best of luck with that effort. From my point of view, I'm interested actually in something else as well, which is that we have a long history of water regulation and law in California. I think some of it has worked very, very well. And as you will hear from me, I think some of it has been a catastrophe and has worked very poorly. It's why we have this overallocation problem and why we have so many obstacles. So I do not view this as, California has figured things out and is here to let Chile know what's going on. I view this as a true dialogue. There are many areas where California itself is struggling to come up with better ways to structure its law and its regulation, and should be looking to study examples and learn from other countries, other states, other nations, how to do certain things better. So I'm just letting you know, and I think why I state that will become hopefully clear by the end of the next 30 minutes as I sort of churn through some of the craziness that is California water law. Okay, so I'm going to, next slide, please. I'm going to begin a little bit by providing somewhat more detail on what I mean by these three terms: overallocation, opportunities, and obstacles. And, in a nutshell, when I'm talking about overallocation, I'm talking about when entitlements have been given to divert water out of stream for surface waters that, for whatever reason, exceed the actual amount of water that is available in the rivers. And sometimes this can be because the amount exceeds all water in the river, meaning it would cease to exist if you diverted all the water. It would be a dry riverbed. Other times it's that we have determined that we need a certain amount of water to remain in stream for ecosystem support, for fisheries, for water quality, and that the amount of entitlements to divert water out of stream would not leave sufficient water in stream for those sort of ecosystem, water quality, and fisheries purposes. So as we think about this problem of overallocation, there are really different types of, for lack of a better word, victims, or people who suffer because of it. The first group of people that suffer from this overallocation are the water users themselves. Water users have made investments and plans based on the expectation that they will receive the amount of water to which it appears they are entitled to. So when that entitlement is not available because it's not there, that obviously can frustrate the investments, whether they're municipal investments, right, for residences or housing, or whether they're agricultural investments. If the water's not there and people have been expecting it, there's going to be some economic hurt within the water use community. The other type of harm that results from this overallocation is of a more environmental nature. As you can appreciate, when we have overallocated our resources, and the government says, oh, we need to leave some water in stream for water quality or for fisheries, there is predictably going to be very severe pushback from the water use community that would like to limit the amount of water that stays in stream to maximize the amount of water that can be diverted out of stream. But I'm also a little bit hesitant to, as someone who represents lots of fisheries groups, one thing that I find, frankly, inaccurate is this division of environmental interests and economic interests. Because at least when I'm dealing with my fisheries clients, they are outraged that their water use gets lumped in with the environmental purposes. My clients would say, I feed my family by fishing, and when you take my water, you destroy my livelihood. And these people actually don't like environmentalists. They don't get along with them in many respects. So for them, it's very much an economic interest. Keeping water flowing in stream to support fisheries for commercial fishermen is not an environmental cause. It's their livelihood. So I would just keep that in mind. Okay, opportunities. What do I mean by opportunities? In the context of this conference, I'm specifically referring to provisions of law, and we'll talk about the sources, different sources of law, that can address California's problem of over-allocation and excessive diversion of rivers and of surface waters. These provisions of law, some of them are contained within California state law. Some of them are contained within provisions of federal environmental law, and I'll discuss those sources as we move through it. But the way I view it is that these sources of both California state law and federal law provide opportunities for the government, for society, to address the over-allocation problem, to address the problem of excessive diversions. And I'm going to try and give you a sense of those types of provisions and how they operate and where they're located, because some of them are statutory, some of them are common law. They have different sources. And then obstacles. Well, in the context of this conference, what I mean by obstacles is that, yes, in terms of opportunities, we have provisions of law that seem like they're available to help address the problem of over-allocation. But we also have sort of countervailing provisions of law, some state law in California, some federal law, but they all apply in California, that actually hinder the efforts of the government to address the over-allocation problem, that undermine it, that are at cross purposes with that. And some of those obstacles are provisions within California's water rights system, and some of those are actually provisions within the United States Constitution that deal with property interests and the way that we regulate them and the way private parties are impacted. So I'm going to try to give you a sense of what those obstacles are. So just to return to my earlier point, so you have a sense, if I were to leave out the obstacle section, you would think that California had a problem and we've come up with solutions to solve it. And what can you learn from our, wisdom and experience? Well, the obstacle section will make clear that's not quite the story. We have these provisions that are deeply embedded in our legal system that pose significant obstacles to our ability to address over-allocation. And if I had any recommendation to my colleagues in Chile is make sure you study the obstacles, because these are provisions of law in the way they're structured in the U.S. that I would not wholeheartedly recommend your adoption in Chile, or at least that if you do, that you have an awareness of the problems that they've created here in California. Okay, next slide. So I'm going to talk a little bit about issues, and three issues in particular relating to over-allocation. I'm going to walk through my three big O's. and I'll start with over-allocation. To understand the problem of over-allocation without doing too deep a dive, I need to talk a little bit about the water rights systems, and I'm putting an S there, systems, S, in California, because California has a very strange and complex set of water rights systems as compared with most other states. In the United States, there are most water rights, nearly all of them, are creatures of state law rather than federal law. With very few exceptions, and I'm not going to get into them, we don't have a federal water rights system in the United States. We have a state water rights system. And in the United States, there are two main water rights systems under state law. The first are riparian state water rights systems, and the second are what most people in the world refer to as prior appropriation. We still use that term in the United States. In California, we often refer to it shorthand as simply the appropriative water rights system, but we use the words appropriative and prior appropriation somewhat interchangeably here in California. So I'm going to tell you a little bit about those two systems and how they relate to how things work here in California. The first state water rights system that we have in the United States is the riparian water rights system, which came from the English common law and was imported into our 13 colonies and was sort of the water rights system used in most of the eastern United States and most of the Midwest, what we would say east of the 100th meridian, which kind of is a dividing line through the middle of the United States. Riparian water rights are essentially real property rights. That's the way to think of them. If you own land, and that land either borders a surface water course or a surface water course cuts through it, congratulations. You are a riparian landowner because of that proximity of surface water to your land. And as a riparian landowner, once again, congratulations again. You have riparian water rights. You do. Simply by being a riparian landowner, you have them. Do you need to file with some government agency, local, state, federal, to get them? No, you do not. In general, can you lose them through non-use? No, you cannot. You are, congratulations again, a riparian landowner with riparian water rights. Importantly, one aspect of riparian water rights is that they are said to be, and we haven't decided on how to pronounce this word here in the United States, but either correlative or correlative. I'm going to go with correlative, since that seems to be the more popular version of it, but I've heard both, and I'm not going to pick and choose today, which means that in times of shortage, which might be caused by drought, which might be caused by determinations that more water needs to be left in stream for ecosystems and water quality, riparian water rights holders share the pain. Let's say that it was determined, for whatever reason, that there needed to be a 25% reduction in the amount of water that was diverted out of a river or stream or some other surface water course. Well, if all of the diverters have riparian water rights, it's pretty straightforward. You want a 25% reduction in diversions, every water rights holder is going to reduce by 25%. And that's how we'll get there. So correlative rights are a very important component of riparian water rights. The second water rights system in the United States is the prior appropriation or appropriative water rights system. This system developed in the 1800s, mostly the mid-1800s in the United States. It's often associated with hydraulic gold mining, at least its origins are in California. And the appropriative water rights system does not require that a water course border or run through a landowner's land for that landowner to have a water right to receive and use water. There are two main principles under the appropriative water rights system, which we sort of crudely refer to as first in time, first in right, and use it or lose it. And put together, those mean that, you know, it's changed a little bit over time, and I'll explain this, but how do you obtain a right, a prior appropriation right? You start diverting the water to your land and you keep putting it to use. And the fact that your water is not pertinent to the water course does not matter. You may need to make arrangements to transport it over other people's land. That's a kind of property issue, but it has nothing to do with water rights. If you're able to get the water to your land and you keep putting it to use, that was all you needed. And the reason we did this was because hydraulic mining required a lot of water. We'd essentially point giant hoses at mountains and reduce them to walls of mud. And the government wanted the gold. We were on the gold standard, so no one was going to stop them. So we came up with this system of, like, if I take it and I keep using it, I get to keep using it. And before California was a state, this was sort of enforced with rifles. If someone else opened another hydraulic mining camp, they would get a visit. They would get a visit from the other mining camp saying, excuse me, but it appears you're taking our water, and I really think you should stop. It's a very crude system, not developed by legal scholars at all, developed very much on the fly based on the economic circumstances. But California, perhaps not in the greatest wisdom, became a state, and in the 1850s decided, I guess we'll just ratify this sort of system that the mining camps have been using and make it our state law. One of the big differences between the appropriative water rights system and the riparian is the way things work in times of shortage. And unlike the riparian system, where things are correlative and everyone reduces together, that is not how appropriative water rights work. As I said, key principle, first in right, first in time, which means there are senior appropriative water rights holders and there are junior. And in times of drought, the senior appropriative water rights holders get their full take. And the junior appropriators get whatever is left after the senior appropriators take their full take, which for some of the people at the bottom of that list may be nothing. So let me use my same example of the 25%, right? Let's imagine the government determines that there's been an overallocation of 25% and they need to reduce surface water diversions by 25%. Well, if all the holders are appropriative, they cannot issue an order saying, hey, all appropriative water rights holders, reduce by 25%. No. They have to go to a list. And that list is senior appropriative water rights holders and their amounts down to the juniors. And you work up, in theory, from the bottom of that list. And what you do is for the junior appropriators, do you know what they get? They get nothing. And the people at the top of the list, they keep it all. Which means there can be particularly dire consequences in times of shortage or drought or any effort to reduce diversions for junior appropriators. And this is an important piece. I'll talk about this. As you can imagine, this is sort of a prelude to obstacles at the end, but it's a very important aspect. So the last thing I'll mention is that in general in the United States, state water rights systems are either riparian or appropriative, but not in California. I'll use the word wisdom and put it in quotes, but California decided early on that it didn't want to choose between riparian and appropriative water rights. So without really explaining how they would be reconciled or integrated, we adopted both. And it's been very confusing and difficult to figure out how they fit together, especially since correlative rights exists in one and does not in the other. So in times of shortage, this gets very, very messy. But California is one of 2 states in the West here that has what's called a dual system, where we have both riparian and appropriative water rights. So that's the first thing to sort of know. Okay, and then I'm going to talk a little bit about, so sort of on the mechanics of the law, how did we get into this problem of over-allocation? And I'm going to provide sort of 2 examples of 2 main things. A question from the panelists to me, I'm just looking in the chat box as it comes in, noting that I am talking primarily about surface waters. The short answer to that is yes, which means I am not focusing on groundwater law. There's 2 reasons for that. One is that given that one of the themes of the conference was about sort of the interplay between water usage and ecosystems, the connections with surface waters and ecosystem support are much more direct than with groundwater, which seem closely related to the theme. The other is that I had a choice of sort of depth or breadth. And if I spend time trying to explain the water right system in California, another system I do not recommend to you, it would take at least 20 minutes. And I would end up giving very short shrift to the surface water issues. So we talked about it, and I think for my purposes, at least at the outset, made the decision to sort of give a more thorough presentation of surface water issues. But I just wanted to respond to that for those of you. Okay, so how did we get in this over-allocation debacle here in California? Well, the first is to understand is that when we talk about appropriative water rights, in 1914, we created a state agency that actually issued water rights. Prior to 1914, you didn't apply for an appropriative water right. You declared it. You posted a little notice at your point of diversion. You submitted some paperwork with an agency saying, I'm diverting this much water, and I'm using it here for this reason. And voila. You had an appropriative water right. No one reviewed it, no one approved it, no one imposed conditions on it. Those are called pre-1914 appropriative water rights in California. And surprise, surprise, very quickly we realized that people were making claims to appropriative water rights that far exceeded the amount of water that was actually in them because no one was reviewing them. So after 1914, we created a state agency. Today it's called the State Water Resources Control Board. I'll just call it the State Water Board. And they actually can, you know, accept or reject or condition, and they issue licenses for appropriative water rights. But when we've had, let's suppose there were all riparians, right? And there was too much water being taken out. The only way that this ultimately could get solved was through what's called an adjudication, which is essentially a lawsuit about water rights. And the type of order that was issued in these adjudications, stream adjudications or basin adjudications, was called, this is kind of an ominous word given the history of the 20th century, but they use the word physical solution, which meant there's kind of a chart which says who gets what under what different scenarios and how much they can take out. And that hopefully that chart bears some relationship to the actual amount of water that's available for diversion. Now, you would think, right, let's think about, for those of you that litigate, right, well, the judge, because he or she is a responsible judge, would hear the evidence first about the available water, right, and would figure out how much water is available for diversion. That would be phase one of the trial, and then the judge would try and figure out, now I have to allocate that available water amongst these parties. That's kind of in theory the way it works. But what often happened with these adjudications is that the parties would get together and they would try to come up with a negotiated settlement in which they would state, you know, their views of what they thought was the amount of available water and then propose an allocation that squared with that available water. And they would then submit this proposed negotiated solution to the court. And the court would then probably look at this and say, I can do 2 years of trial, or I can just approve this as my order. all the parties seem to have agreed upon it, right? And many times what happened is the court simply, without making its own findings, independent findings about the availability of water, adopted these negotiated solutions as its order. But here's the thing. Did any of the parties to that order have any particular reason to curtail their entitlements to square with the amount of available water? Not really. And do you think they generally had overly optimistic views, probably not very scientifically credible, of the amount of water that was available? Probably. So the court put its stamp of approval on these adjudications, court orders that said how much water you're entitled to take, that, for lack of a better word, were hydrologically delusional. They set forth court-ordered entitlements to water that was not there. And there was not a lot of incentive for people to try to reopen those adjudications, because it would probably result in a reduction of their water rights, right? So we have many, many, many adjudicated basins and adjudicated streams and court-ordered entitlements in which the overallocation is baked into the adjudication. Am I going to recommend that you adopt this approach in Chile? No, I am not. But that is part of the story of how we had overallocation. And post-1914, we had a situation where, okay, now we have a state agency that's supposed to be independently examining these applications, right? And they're supposed to be making determinations on how much water is available and determining whether to issue post-1914 appropriative water rights licenses, right? So everything's going to be okay going forward, right? You think? Well, it got better. It got slightly less worse, but the water board itself was fairly understaffed technically. It didn't have very good information about availability and drought scenarios. So it often relied on the hydrological opinions presented and information and analysis presented in the applicant's application for an appropriative water rights license. And if you think about it from the position of an applicant, they had every motivation to overestimate the amount of available surface water so that they could get their license issued, right? So if you have a scenario where the agency itself is understaffed and they have poor information and they're relying on the somewhat inaccurate, overly optimistic information in the application, and now, in addition to adjudications by courts, we have the State Water Board issuing licenses to people that says they have entitlements to water for water that was often not there. Am I going to recommend this system to you in Chile? Aspects of it, the idea in theory that you have an independent regulatory agency that makes these findings is a good thing. If you don't provide it with the resources to do its job, it doesn't work very well because you end up relying on the applicants. So this is a bit of an overview of how we got into this mess. I'll move on to the next slide now. Just trying to stay on time. Don't know how well I'm doing, but trying to keep track. Okay.
10 minutes left, Paul.
10 minutes left. Then I will, maybe you can grant me 12. I will quickly run through some of the provisions of California and federal law, and I do mean quickly, that have provided some opportunities to address the overallocation problem. And I'm simply going to hit four, the sort of four big ones. The first three, reasonable use and public trust and California Fish and Game Code, are largely creatures of state law. The fourth one, the Federal Endangered Species Act, is a creature of federal law. Reasonable use. We have provisions of our California Constitution, which was adopted, this reasonable use provision was adopted in 1928, which states that it is unlawful to use water in a manner that is unreasonable or wasteful, and that it is also unlawful to practice methods of diversion that are unreasonable or wasteful. And we've adopted parallel provisions nearly identical in the California Water Code that give the State Water Board the authority to enforce this. We have a large body of law establishing what, under different circumstances relates to reasonable and wasteful, but we have a number of decisions that relate to allowing sufficient water in stream to support fisheries and in-stream flow, particularly for salmon and steelhead trout here in California. We have decisions stating that it's unreasonable to divert so much water that it has significant effects on water quality. This is often related to seawater intrusion and salinity levels where there's not enough in-stream flow coming through. But we've had other interesting reasonable use decisions. The use of flood irrigation to drown pests like gophers and rabbits has also been held, at least in certain regions of scarcity, to be unreasonable and wasteful. The use of earthen ditches to transport irrigation water has been held in certain settings to be unreasonable and unwasteful because so much of the water is lost to percolation in transmission. And we also have some provisions that have stated that the use of potable water for certain uses, such as highway landscaping or cooling power plants in California, is unreasonable and wasteful because you can use recycled water or brackish water, certainly for power plant cooling. You don't need to use potable water for that. So the reasonable use provisions is one important area. Public trust law, I'll try to get this down in 2 minutes, but public trust is a theory of law that we inherited from the English common law, which said that the Crown had certain obligations to manage certain things like rivers and fisheries for the benefit of the public that could sue them as sort of beneficiaries and sue them as trustee. We have had a number of decisions in California, the most famous being a decision called National Audubon, that said allowing excessive diversions, at least the State Water Board, is inconsistent with public trust obligations, and that the state has public trust authority and actually not only authority, but an obligation to regulate diversions to provide protection for public trust resources, which include fisheries, quote, whenever feasible. California Fish and Game Code, which is state law. We have provisions relating to dams that state that all operators of dams, including the federal government was surprised to find out that they were subject to this, have an obligation to release enough water below the dams to maintain fisheries in, quote, good condition. We have a nice, inconsistent, rich body of case law on what good condition means, but it means in terms of in-stream flow in fisheries that these provisions of the Fish and Game Code require operators of dams to release some level of water downstream. And then under federal law, we have the Endangered Species Act, and we have many fisheries and fish runs in California that are listed, particularly salmon and steelhead runs and another species called Delta smelt. The Endangered Species Act provides for the designation and protection of critical habitat. And critical habitat for fish is, long dramatic pause, water. So the provisions of the Federal Endangered Species Act have been used to curtail diversions that adversely affect the critical habitat for endangered species. I'm running out of time, so I'm going to go to my last slide and quickly mention one I've already spent some time on, two important obstacles that hinder efforts to address overallocation, or put another way, that make it difficult to rely on those provisions that provide opportunities to address it. The first, which I touched on a bit already, is this problem of senior and junior appropriative water rights holders, that there is no sharing of the pain between appropriative surface water rights holders. And just to clarify, the existence of these senior and junior water rights holders doesn't affect the police power of the government to curtail water. It doesn't. They have the authority to do it, but it means that from the junior water rights holders, there is going to be tremendous political and legal efforts to avoid reductions, even if they're for environmental reasons, because those junior appropriators, the result of even a 10% reduction for the people at the bottom of the list means they're destroyed. Let me be clear about this. They are destroyed. They will get nothing because there is no sharing of pain. It also means that if the government says, hey, senior water rights holder, I want you to reduce your water too. If you try to do that without first curtailing the juniors, the senior water rights holders will claim that you have unlawfully taken, this gets to my next point, their property interest in their water licenses. And to give you a sense, when you're buying land, like in the Central Valley in California, the cost of land that has senior water rights versus junior might be 5 or 10 times as valuable. And their point is, I paid a lot of money to buy land with senior water rights. And those junior water rights, they paid for cheap land, and that's what they got. So don't tell me I need to share the pain with those people. I paid a lot of money for these better water rights. And you don't just come along and tell me to share the pain. It doesn't work that way. So if the government tries to take those senior water rights, they'll have a lawsuit, and this will be my last point, and hopefully I'll get reasonably on time here, is that there is a provision of the United States Constitution, the Fifth Amendment. It was actually developed during the Revolutionary War, but it says that when the government takes private property for public use, it is required to pay the owners, the title holders of that property, just compensation for what they take. Now, this doesn't mean that this doesn't affect the police power of the government to take it. It says, no, you can take things for public purposes. They were thinking probably of barns and livestock in war to house troops or feed troops, but it doesn't really matter. It just says if you take someone's property, you have to pay them. And we have a number of decisions, they're not very coherent or consistent, that state that when the government tries to curtail diversions by reducing people's entitlements to water, they are taking property interests, whether those interests might be recognized in a court adjudication, in a water license, or some other form. You're taking someone's property. Do you have the right to do that? Absolutely, government. You, of course, have the right to do that. Do you have to pay them when you do it? That's the question. So to give you a very concrete example, and then I'll end here, let's suppose, because this isn't hypothetical at all, there's some rivers in California where they say, hey, it looks like there's not enough water in stream for salmon and steelhead trout. We need to reduce that amount of water that's diverted by, I'll use the same example, 25%, right? And they say, okay, we're going to order reductions of water rights holders by 25%. And those water rights say under the Endangered Species Act or the reasonable use provision. Those water rights holders say, absolutely, government, you are fully entitled to exercise your police authority. So you're taking 300,000 acre-feet of water, and let's see, the market price for that is $1,500 an acre-foot. So you'll be sending me a check for how many tens or hundreds of millions of dollars to exercise your police authority. And the government often does not have the funds to pay for that, which means this gets tied up in litigation or legal claims, but anytime you start taking someone's water rights, the government, you're likely to provoke a claim. I can't sort through the case law with you right now because it's not very consistent, but people are going to claim that you have taken their property. And collectively, these two aspects of law, which operate in California, senior and junior appropriative water rights and the takings provisions, act as significant hindrances on the ability to use those other provisions of law to address overallocation. And I think with that, I am completely out of time. So I will stop there and turn things over to Camelia or our other presenters.
Thank you very
You
much,
can go back to
Paul,
the first slide if you want.
for that very good explanation of California's water law systems, to use your phrases. You were just on time, so that was very good. So now I want to pass to Natalia Dasencic. She's a lawyer from the University of Chile. She has a Master of Science in Governance of Risk and Resources of Heidelberg University. And she is also secretary of the Maipo River Surveillance Board, which is one of our surface water user associations. Natalia, you have 20 minutes.
Okay, thank you very much, Guillermo. It's a pleasure to be here. I want to thank to the organization, and especially to Camila Bettiger, who gave me this space today to be here. Okay, I'm going to talk about water rights, especially, sorry, please wait a minute. This part of the presentation refers to the surface water allocation system in Chile. On the current scenario of over-allocation of the resource, it's to say, as Paul said in his presentation, when water rights title exceed the amount of water available. I'm going to start with a statement that could be controversial, but anyway, I think it's right. This statement is contrary to what is often claimed. It is necessary to clarify that the over-allocation of surface water course in Chile didn't occur, because of the enactment of the 1981 Water Code, but at least 100 years earlier, as will be seen below. In fact, the history dates back to colonial times, and the first formal antecedent of over-allocation here in Chile, we can find them in 1972. In order to explain that, I have to make a little brief of the different stage of our legislation, and we think that there are five stages of legislative periods. First of all, as I said, I'm going to start with a little brief of colonial period, because in this period we can find a coexistence between two doctrines, each with its own theoretical foundations. On the one hand, water belonged to the nation or the crown. That means public domain, and in the other side, or on the other hand, waters can also be the object of real permissions to use them in the form of grants as a reward and recognition of the efforts made by the conquerors in the West Indies. Thus, since the colonial times, as a general rule, waters belonged to the crown, especially the water of navigable rivers, except for the express concessions, which practice became innumerable, and concession regime was set up, which the grants were given by the governor of the place, with the knowledge of the corresponding cabildo or the town council. I think this period is important because of two facts that are the distinguished characteristic of our water law. The first fact is that there was no general regulation for their use and control. That is why this was left in the hands of the interested parties, which will constitute a distinctive and characteristic element of our legal system to this day. Indeed, in the absence of a general regime for the use and control of water, suggestionary arrangement began to emerge in time of scarcity. I refer in this point to what we call informal institution. Maybe for the Anglo-Saxon world, they call just institutions. This institution consists in a private arrangement, as in common law, between interested parties who decide to their satisfaction almost all terms of an agreement with governmental authority being used to enforce them. As an example of this institution or informal arrangement, we can find that what we call turnos or alternative withdrawals. Another informal institution are the proportional distribution of water. This kind of arrangement exists until today, and we have now a more sophisticated arrangement like swaps between holders of water rights. The second fact consists of this period is respect for the local costume. As an example of this, we can see the distribution water code mode of the Incas, yes, called ayllus, which were formally respected and incorporated into the legislation of America. The same happened later with respect for riparian uses. Then we start a second stage of our legislation. It began with with the Republic in 1920. This is a pre-codification stage, and characteristic of this period is the dispersion of the norms about the water's subject. In this period, as milestone could be mentioned, the municipality law, which established that grants or permits to draw water from a river or corresponded to the administration where the intake was located. This law also established that the police rules on the waters of the rivers that divide province or departments would be established by the President of the Republic. But the most important law in this period was the Civil Code enacted in 1955. This body of law systematizes and establishes the general rules and principles of the water regime. In the first place, the Civil Code distinguished between private waters and public waters. Private waters are those that born, run, and die in the same property, and those contained in lakes not navigable by ships over 100 tons. The ownership, use, and enjoyment of these waters correspond to the owners of the banks and pass to their heirs or legal successors in the domain of the property. Then we have the public waters that are all waters flowing in the rivers, natural water course, and lakes navigable by ships of more than 100 tons. Thus, public water are national goods of public use, and nobody can use them without the corresponding water grant. During this period, there was a great heterogeneity in the content and the scope of water grants. Some were temporary, others indefinite. Some outside their transfer, there were commercials, others did not. Some were expressed in irrigators or regadores, how we call here in Chile, other in blocks or hectares irrigated. The Civil Code recognized previously legally acquired rights, the right of riparian uses. I think not in the way, as Paul said, that happened in California, but there were recognized. And the Civil Code recognized also water grants granted under previous legislation. But a part of the Civil Code, there was another norm that it was very important, and this was the Ordinance of 1972, 20 years, it was enacted 20 years after the Civil Code. And why this ordinance is important? I think that it's important because it lies, the importance lies in the fact that it's the first regulatory body that established the basis of distinguish between permanent and eventual grants that maybe are similar to senior and junior water rights in the United States. And this ordinance sets the line of when it is understood that a riverbed is legally exhausted. It's useful to read this paragraph of this ordinance. It's antique Spanish, but I think it's possible to understand what it means. It says, when a shortage of water occurs in the rivers, dividing department or province in such a way that it's necessary for the good arrangement to submit them in turn or alternative withdrawal, a distribution shall be made between one bank and the other, the distribution being made in the most equitable manner possible and in proportion to the amount of water that each channel has ordinarily carried. So this is the basis that we have until today, and we have now in our water code that, that refers to permanent and eventual water rights. So the water grants that are granted since the promulgation of this ordinance in the rivers that at certain times are subject to alternative withdrawals because their waters are not enough to meet the needs of existing withdrawals, will only give the right to draw water when such rivers are not subject to alternative terms or alternative withdrawal. But while they are not, they will have a share in the distribution of water. Okay, I'm going to advance because I think there's not enough time. So next we have a third stage that started in 1951 with the first water code that we had here in Chile. And in this code, in order respect to the domain, it didn't make any modification to the existing regulation except that the use of riparian owners was eliminated. No more riparian owners, and all users were subjected to the same rules for the concession of water grants. In this way, the concession procedures was unified in the hands of the administration. It was also established in this code that the water grants were to be granted provisionally. That was very important, and it's different that we have now in our days. So that the holder could carry out the studies and works necessary for the use of the water, and only once there were built, the right became definitive. The hydraulic works was built, the right became definitive. The 1951 code also innovated in order to establish preference for their allocation. In first place, we find drinking water supplies and service from towns, for towns, sorry. In second place, domestic uses and sanitation of towns. Third place, use of railroads and saltpeter desalination. 4, irrigation. 5 place, electric power. 6th place, industry and factory. And the 7th place for other uses. In 1867, the law of agrarian reform introduced a radical change to the scenario, and especially to the water domain regime, which sought a high degree of state intervention. In effect, all terrestrial waters that were in private ownership were incorporated into the public domain, declared of public utility and expropriated. It was established an administrative right of use.
Natalia,
And yes, 5 minutes. Okay, and this could not be transferred separately from the land. These rights could be reviewed by the authority and could be terminated in advance. It was expressly declared that person whose right had lapsed would not be entitled to compensation. So, as well known, in 1989, produced the 5th stage of our legislation, and the new code put an abrupt end to many of the regulations adopted by the previous regime. In first place, it sought to leave without effect the provision of the agrarian reform, and reestablish the regime of private ownership of water rights that had been enforced until the agrarian reform law. In second place, modifications were made to the Constitution guaranteeing private ownership, thus seeking to give legal certainty to investment and business. Some people say that I'm going to say that the drafter of the 1981 code, Mr. Luis Figueroa, points out in his book that it didn't not start from scratch, but took up what had already been developed up to the enactment of the agrarian reform law. However, there were a major difference with the regulation in force prior to the agrarian reform. The concession of water rights had to be granted as long as availability allowed it, and it was not against the rights of others. The authority could not deny it for the other reasons, nor could the authority give preference to certain activities or rights of use are equal for human consumption, irrigation, or mining. And the reallocation had to take place through market mechanism. Other problems also emerged, such as speculation and the monopolization of water rights, exacerbated in many places by the lack of coordination and organization among water right users. As conclusion of this part of the presentation, the over-allocation of water rights didn't begin in 1981, but at least 100 years ago, when grants or eventual rights began to be used. This situation was aggravated by the lack of organization and coordination between the holders of water rights. And today it's not only necessary to order the use in many places, but also to adjust the scenario on the demands for essential uses, especially in rural locations not covered by sanitary concessions and environmental demands. That is all. Please, Camila, it's your turn.
Thank you, Natalia. Next, we have Camila Böttinger, lawyer of the Centro de Derecho Regulatorio y Empresa of the Faculty of Law at the University del Desarrollo, Universidad del Desarrollo. Adelante, Camila.
Thank you, Guillermo. Natalia had made us an exploration of this distinctive legislative periods or water codes in Chile, which have been, in words of Karl Bauer, it's not mine, like a pendulum. They're going from one extreme to the other. The more representative are the last ones. 1979, a reform, an agrarian reform, versus the 1981 code, which is has a very liberal approach to the water rights. So we have a whole history here. We have, and every legislation has recognized the previous water rights, disregarding that in some points were non-commercial or mortgages or were expropriated, but the constant in our legislation is that water rights are recognized and somehow protected. And now the current situation that Natalia presented. Instead of obstacles, Paul, I use the word challenges, because in Chile now, we're facing several challenges regarding the regulation and use of the water resources. The general assessment by, I would say there's an agreement, is that the current situation or the current regulation as it is not sustainable due to several factors. There are inequities in access, distribution, and allocation of the water resources. The demand for the resource, both domestic, industrial, agriculture, mining, and other, have increased while the flows have decreased. And though under the 1981 Water Code, Chile has made tremendous improvement in agriculture, industrial, and especially in sanitary services in the urban areas. In the rural areas or outside the cities, the situation is critical. We have a lot of people who are being served by cistern tanks for their daily consumption. So also, Chile is a very diverse country in geography and climate. But what we have in common on the first challenge, I'm thinking here, the first challenge is like a physical challenge in which our friends, the hydrologists and engineers are the most needed, is we have the physical challenge of facing the effects of climate change. Chile has 7 of the 9 risk factors of climate change. And we are facing, from 10, 15 years ago, what we'll call the mega drought, with the drier years for never registered, with increased temperature, heat waves, reduction of rainfall, and snow, which have been dramatic changes from what we knew. In the 1980s, we have a very abundant period of rainfall. So the scenario has changed very dramatically. Thus, summarized to the over allocation of water rights, who have by general a fixed volume. Natalia explained the proportional reduction, but that takes place mostly in surface waters with a surveillance board, where the user organizations are in charge of that. The other water rights have a fixed volume. So the decrease of available flows summed up with the increase of the use of these water rights that were granted have made a very difficult situation for different sources of water. The other challenges we're facing is under regulatory scenario. Everyone here I is aware that Chile is now in a constitutional debate with a convention ready or implementing to discuss a new text for our fundamental rules. And water is one of the main issues that has to be, is to be addressed by mostly every of the elected conventionals have a statement to say about the water situation, because it's a crisis. We have an hydrical crisis. And the main upstairs, and we're going to talk about that in the fourth session, but the debate there is the human right to water, the role of the state over the water resources, and the environmental function of the water resources. In parallel to that, we have, for the last, I think, 7-8 years, a water code reform in Congress ongoing, parallel to this discussion. Changes in water rights have been the focus of the water discussion in law in Chile. Mostly the bills address that. They try to change the characteristic of the water rights, which Natalia explained were very different under the 1951, 1969, and 1991 code. For example, this reform tries to change the water rights to a fixed term, to establish a fixed destination, and a prioritization of uses, which Chile has not now. That is a change of approach, more like the 1969 water code. But every legislation has to deal with the existing situation. So the water right holders are now vested with a property right over their water rights. Like, we have the water right, and over that we have a property right. Yeah, it's not a property over the water, because the water is a public good. But this, although the authority has certain powers to intervene on them, the classic vision of property hinders the possibilities to modify or adjust the water rights. On the other side, the strong protection is criticized for a right that is exercised over a public or common good. So there we have the question: are the changes going to be a regulatory taking, an adjustment, or a restriction? And there, Paul, we have the same discussion if the water right holders are going to say, we need compensation for this. The other challenge, if we shouldn't have enough with this, is in management of water resources. Technically, this should be a technical problem more than a political, but that's not really true, because any change needs political address, resources, and agreements. And the management of water resources have been the main problems remain in information, measuring, and control of extractions. We cannot manage what we don't know we have, where we have it, how many, and who has rights or entitlements. Some advances are being made, it's true. The Water Directorate has implemented water mediation controls systems in, for example, on the groundwater, and in many surface basins there are, but we have a lot that we don't know. The next is the demand for the integration of environmental and social interests along with the water uses. The in-stream flows are established by every water right. We do not have in-stream flows or ecological flows for source or certain sectors of a basin. So it's very difficult to have or enact a in-stream flow for a certain surface area of a basin. The question maybe would be to change the approach like the Australians did this, not how much we can take of the river, but how much we have to live inside the basin. And that needs a coordination within the basins, hopefully with a view of the integrated water resource management. The surveillance boards, where they exist, we don't have in every basin, are doing the best they can with the distribution of the available flows, but they can't, for their object and resources, do much more than that. Actually, water supply has been adjusted within the users of sanitary use in preference to irrigation, for example, in the basin of Maipo for Santiago. The fourth challenge is the institutional challenge. One of the main problems in Chile has been the where and who is and how many resources has the authority, the public authority regarding water. We have a sectoral authority. What I mean with this, the Water General Directorate, which is the public service or administration branch, which is in charge of this, is a division within the Ministry of Public Works. It's not a ministry of its own, and but in the Latin system or the administrative system in Chile, we are a United Nation. We are not federal. So the importance of any service or public power is related to its hierarchy or an appointment. And here we have that the waters, all the water authority is a division within a ministry which is in charge of public works like infrastructure, aviation, viality, etc. There's a bill that has been ingressed to the Congress proposing a subsecretary of water resources. But the approach is still within a sectoral ministry, which is more of infrastructure or irrigation, and the other uses have to be coordinated with environmental authorities. We don't have a central authority or a central approach to water in all its aspects. But then the low hierarchy, resources and powers of the administration also is an issue. And especially a lack of complete registration of water rights and uses. In Chile, we have at least 2 records, parallel records or registrations for water rights, for users organizations, which are not either comprehensive, complete, or easily available. The authority has updated the hydrological information, that's right. But there's a gap between what we know of how many water rights, how are they, and how are they characterized, their treats, yeah, and the public information. So, to finish, we have a lot of challenges. We're in a time, we're in discussion, we have the crisis before arise, so the discussion is here, finally. Although while we're working in this team, have been discussing this for, Guillermo, 10 years more. But now we are in the center of the debate. And so we have an opportunity. All these challenges are related and need an integrated and technical approach, but also with a determined political decision. I'm thinking I can't but think of the case of Australia. It wasn't a smooth change, but it was done. They have to buy off some water rights. They had to reenact some laws, but the change is inevitable, I think. This is my opinion. We need a political decision to address this scenario, but with appropriate reforms, financial resources, and ultimately a transversal collaboration of all the parties. If we discuss who's to blame, we're gonna dry out. So here, like an hydrological cycle, I propose the 4 main opportunities we have. A new being, I think it's the main one, a new public institutionality. An agency like the World Bank advised, a ministry, a subsecretary within the public works. I prefer an agency, but there's also the political agreement to be made. An integration of the environmental instruments within the regulation of the water law. The water code doesn't address the environmental function until 2005. We need to integrate in-stream flows, the wetlands protection, and other protected sources. There, then, inevitably, we have the adjustment of the water rights. Hopefully, to move to a volumetric distribution more than a fixed volume, a coordination of uses, and the respect of environmental functions within every basin. And to do that, we need to invest and develop technical solutions. Desalinization, water reuse, also reduce consumption. In Chile, we use a lot of water. The domestic use is high for our arid situation. Enhanced infrastructure, we lose a lot of water within the channels or within the pipes. Efficient irrigation systems and transfers within users. We have to be efficient in the use of the water we have. And that could be all. Thank you.
Thank you very much, Camila and Natalia, for your presentation. We now have 30 minutes for questions and answers. Probably between yourselves, you have some questions. I can put forward a couple of the questions that have come up during your presentations. The first one, if I can ask Paul some of the issues that have come up. The first one is with the restrictions to limit diversions that you presented. How do you ensure potable water supplies? Do you have extra powers for the state to apply that? The second one is with the taking and just compensation and the litigation that you presented. Has this type of conflict reduced its application? This question comes from the situation in our country where our water authority has the authority to expropriate, take and just compensation, but it has never been applied. Those are two questions that I could start with for you, Paul. Your mic.
Thank you, Guillermo. I'll try to take them in order. The first is that within California water law, at least in terms of what we call consumptive uses, we also have a sort of a listing of priorities. And domestic use, for sort of basic vital human needs is given the highest priority of consumptive uses, which means that there can be some additional resources when you're speaking in terms of, I think you meant potable water for human consumption. California has also adopted about 10 years ago a sort of human right to water statutory provision. It's not enforceable in the courts, but it gives authority to agencies. It actually explicitly says you cannot enforce this in the courts, but it does give agencies authority to act to try and expand potable water sources, particularly to disadvantaged communities. We have a number of those that are facing polluted water sources in the Central Valley. So the issue of providing healthy potable water, particularly to disadvantaged communities, has been a priority. It's reflected in the priority of consumptive uses and in this more recent legislation around the human right to water. The second question related to takings is that most of the action in this area in the United States has not been taking place at the administrative level. It's been taking place in the courts. In particular, it's been taking place in a court called the U.S. Federal Court of Appeals, Court of Claims. But so essentially, most of these cases have involved the attempts by the federal government to curtail diversions to fulfill its obligations under the Endangered Species Act. And the water rights users that have been on the receiving end of those curtailment orders have then filed claims against the federal government for compensation. And the cases are not super coherent. The U.S. Supreme Court has not taken up the issue, but we do have a handful of cases where they have definitely recognized that this implicates property interests, and they've often jumped into whether there are background principles of state law that limit that property interest such that it's less finite. And the best way I can describe those decisions is it's like herding cats. They're not internally consistent, and often even on their own, they don't make, they're not very coherent. But we do have some judicially, I mean, one case that was very interesting is that this was a case called Klamath Irrigation District. It actually involved Oregon rather than California. But the court said you can't have a right under the federal constitution to a fixed amount of water that you don't have a right to under state law, because they said under state law, because of things like reasonable use, public trust, you don't really have a fixed entitlement to water anyway, partially because of climatic conditions. So to claim that you have a fixed water right is both hydrologically incorrect, but not even consistent with state law principles. Those are the types of arguments. But my point is simply, it's an argument that is being raised, and it's an argument that in certain conservative political circles in the United States found and finds a lot of traction. We had leading people within the Justice Department, both in the Bush administration and with the Trump administration, that were tremendously receptive to this position. So they were not going to defend the right of the federal government against the takings claim, or not very effectively, because they actually agreed with that position. So that gets more into politics maybe than we need to. So I'll leave it there if that's a partial answer.
Great. Thanks, Paul. I know you have a question for Camila and Natalia. You could propose it to them now.
Sure. I'm not sure if it's a question or a comment, but Camila, I was very interested in your comments about how on water management that, we, from a technical standpoint, we just need better information, right? About everything, about available water, about climate change, about what fisheries need, all that stuff. And that was really a technical issue. My experience in the US is that it's a little blurrier than that, because here's why. Water rights holders are smart. And they know if there's better information about how bad the problem of overallocation is, there's going to be a lot of pressure to solve it. And what is that going to mean? Efforts to reduce their diversions. So one of the strategies that has been used far too effectively in California is to defeat efforts to obtain better information. Because if you don't have the information, you can't regulate. This has been particularly true in groundwater. We've had, for 50 years, they've been successful in saying you don't have to actually report how much water you're pumping. You don't have to report it. Because they know if everyone knows how much everyone's pumping, there's going to be pressure to reduce the pumping, right? They're not dumb. So I guess I was simply pointing out that it sounds like a technical issue, that everyone should agree that better information is better, right? There's not agreement in my experience in California on that at all. In fact, there's a deliberate political effort to remain ignorant, because when we're ignorant of the underlying information, we can't act. There's no basis to act. So the strategy is, let's stay dumb. It's a terrible strategy. But I don't know if you've experienced resistance to just efforts to track and get information, because people know where this is going. It means they're going to be regulated. So why would they encourage it or allow it? Yeah.
Thanks, Paul.
Guillermo laughs and laughs. I want to know why you're laughing.
Yeah.
It makes sense.
Absolutely. We have a saying here, in every kitchen boils the same thing. I don't know how to translate it. En todas las partes se cuecen habas. I don't know how to say it in English, but yes, what you're addressing is totally real and true. we have a saying here in Chile, I'm not going to say it out loud because it doesn't use a very nice word, but to stay dumb or to stay ignorant or to play dumb, it's a very, very good way of passing through the controls and regulations. So what I was proposing is not from a water right owner view, but from a water policy need. And the thing is, I understand what you have faced in California, but the water code, the 1981 water code, gave the administration the power to force or demand water right holders to install volumetric control. And nowadays, I can tell you that for the past 2 years, and Guillermo can correct me if I'm wrong, the groundwater has been the focus to obligate or demand the water right holders to install those devices and to send the information online, or at least very promptly, to the authority, exactly to know how much they're pumping and how they're, especially groundwater is not known until it's used, right? You don't
Right.
have the information like surface water, which is at the eye, right? But Chile, the water code, the 1991, has always had that authority. And like Guillermo said, that water code also has many powers that the authority hasn't used. For example, the reduction of the use of groundwater rights. The water code is from 1981. It has never been imposed, ever, not once. 40 years. And the expropriation ability has never been used either, and it's there. So there's not only a problem of regulation, it's a problem of policy and politics, as you said, and also of resources. We have an administration or a public authority with little resources to do what needs to be done. Not only powers, but also resources, technical resources. I know that data, it's not only a technical issue. I'm thinking it's a technical way to gather it. Yeah, I'm not trying to put it technical because it's better received when you say it's a technical issue, right, Guillermo?
Oh, yeah.
Yes.
Because we also have the problem of the property approach. So I'm trying to separate the problems because the focus has been the property. If you change the water rights, or if you diminish the volume, or if you establish an in-stream flow, you're touching this umbrella, which is the property right over the water concession. That's a bit of main discussion. I'm leaving. Natalia wants to say something.
but I think that it's not the main problem here. The problem is DGA or water agency with a chronic lack of resources is in fact is a little part of the ministerium. I don't know how you say Ministerial of Works.
It's a division of a ministry.
It's a division, a little division with a chronic lack of records. And about you said, Paul, there is a proverb here in Chile. We said Río revuelto, ganancia pescadores. We could translate it, all fishermen in troubled waters. So everybody win in troubled waters. So the information, it's a really problem. But I think with the last norm that forced to water rights holders to transmit online the withdrawals will improve the situation, I hope.
Thanks, Natalia.
The only thing I would add,
yes, go ahead,
was
Paul.
just to give you a sense of how ugly the politics are. So in California, we have groups affiliated with Central Valley Agriculture, like the California Farm Bureau. that essentially if any candidate runs for office, governor, state senator, congressman, whatever it is, and they take the position that they want to insist upon the collection of better information, Amelia, that individual candidate will be targeted for destruction, personal destruction. And that is known. That is known that if you touch that rail and you go there, because they know what you mean by information, it's stage one of regulation. They know that even many Democratic candidates in the state of California have decided for their political survival, it is better to not touch that third rail. The most classic example here in California is Democratic Senator Dianne Feinstein. She might be progressive on some issues, but she does not mess with Central Valley agricultural water. She takes care not to do that, to not find herself on the receiving end of that, because people's political careers have been destroyed over it. Take how ugly it is.
Paul,
Wow.
let me.
If I can move
Guillermo,
on
please.
to a couple of other questions.
We could be all day
subject-
here. Okay.
This subject is for all the rest of the day, exactly. Natalia, Philip had a question with respect to your presentation, where he understood that we have correlative water rights in the sense of what Paul presented. And does this system of correlative rights present different challenges? For example, decreasing reliability of water supply for certain users?
I think it's not exactly a correlative system. Here in Chile, we have two kinds of water rights: the permanent rights, that it's similar to senior rights, and the eventual rights. The permanent rights, you can use them when there is enough water in the amount of water that allowed your title. So there is no problem when we have availability. Please help me with that word.
Availability.
You can say enough volume.
Okay. Enough volume. Okay, enough volume. And when the scarcity comes, everybody, the distribution make in proportional to the titles. Then we have the second type of water rights, the eventuals, and the eventuals can withdraw waters only when there are more volume of water. First, you have to satisfy the permanent rights in the volume that correspond, and only if there is an exceed, you can exercise your eventual water right. I think challenge about it, talking about the challenge, I think we have to talk about expropriation, and that has been a taboo topic here in Chile. There are a lot of people that say, why I have to pay for the expropriation if the state give you for free the water right? And it could be true for the original Spanish conquerors that had the water rights for free or in reward for his adventures here in the West Indies. It could be true for this case, but the major people here in Chile now had bought his water right in the market. They had paid amount of money for his water right, and this is the general rule. So why do I have to why I should quit to my water right without pay back? That is the taboo discussion right now. I think we have to talk about it. And we have to solve, I don't know how, because there are a lot of politics circumstances that disorder the debate.
Sorry about that. Thank you very much, Natalia. There is a question that has been asked in the Q&A box, which I would like the reaction of all three of you. And that question is, what do you think about changing to a basin regulated approach rather than a region or country approach? Maybe we can start with Camila, then Natalia, and Paul.
Well, thank you. I already gave my position, and Guillermo and Natalia knows that we have this debate ongoing now in Chile for some time, especially in the technical areas like Fundación Chile or so-called, but it's the integrated management of water resources. Chile has supposedly 101 basins, right? With different climates, with different geography, very different within the north, the central, and the south region. These macro zones will be different in a different way, affected by the climate change, affected with a different way. And geographically, and Natalia has a master in governance of geography, and we have to respect the reality. The reality of the hydrological cycle is the basin. It's not the administrative region which we politically divide a territory. We have to respect the principle of the flow we have in Chile in the Article 3 of the Water Code, or the principle of reality. So I think, and we don't have to invent the wheel here. We've discussed this before. We have to look to other systems how have they solved this problem? And the basin approach has resulted, to this day, the better way to integrate the different interests, ecological, withdrawal for agriculture, uses, and to integrate not only the water users, the water right holders, but to integrate the other persons that have, we here in Chile, we are in a discussion of participation. We're in a discussion of considering what others, or what the people that are there think about something. That could be a way to integrate and stop conflict, or at least merge the conflict within a table and not in opposed corners. You're muted, Guillermo.
That's the phrase of the year after this pandemic. Natalia, what is your opinion on this question?
I absolutely agree with Camila. In addition of that, I think there is each basin is a universe. We work in Maipo River basin, and there we have the Santiago city, that is a huge city that consume water supply, need water supplies for 7 million people. And Maipo River is the only source almost to the Santiago city. So the rules for the Maipo couldn't be the same for another basin, which I don't know. I think in the basin of the south of the Patagonia, which the uses are different, totally different for tourists. I don't know, environmental demands. So it has to be different for each basin. Yes, absolutely agree.
Thanks, Natalia. Paul, how does that sound to you? Particularly if I can add, in your case in California, you have a lot of water transfers. So would an approach like that be applicable? Paul, you're also muted.
First of all, I'd just like to say I adore the phrase, the principle of reality. I plan to repurpose that, Camelia. Thank you. I think we've had a lot of discussion in California and the West around what we call watershed governance, which I think is related to this, which is it makes a lot more sense to try to manage our surface waters on a watershed or basin-wide level than to manage them as individual streams. And we've had examples of where that's not been done and it's created problems, and we have some encouraging examples of where it's being done and working better. So I'll give one of each. An area where it's worked very poorly is the Colorado River Basin. We have a federal law that allocates the waters of the main stem of the Colorado, but says nothing about its tributaries, which means you can divert as much water from the tributaries without violating the rules relating to the Colorado River, which of course, getting back to Camelia's principle of reality, is hydrologically delusional. Because if you divert the tributaries, you're going to reduce the amount of water in the main stem, which won't be there for diversion. But the law is written such that it clearly says this only relates to the main stem, not the tributaries. And a lot of people have criticized that, saying this doesn't make any sense. And I think that's an example of where we're doing a poor job. An area in California where we're doing a better job is that one of the two main rivers in California is called the San Joaquin River. It flows sort of up into San Francisco Bay from sort of the southeast, and there are a number of tributaries to it. And there's been a lot of work on restoring in-stream flows for fisheries and water quality to the San Joaquin. The State Water Board, about a year and a half ago, issued new in-stream flow requirements for the three main tributaries to the San Joaquin, and said, how can we possibly ensure the adequate flow of the San Joaquin and into the bay if we don't establish standards also for the tributaries for the San Joaquin? Now, when you say this out loud, it almost sounds obvious, right? Well, the tributaries provide the flow, so you got to make sure there's enough going into the big river. It sounds obvious, but this is the first time that our State Water Board has done this, and I credit them for doing it. What I can tell you is there are 3 pending lawsuits challenging the tributary flows right now on all sorts of grounds. So it's encountering a lot of resistance, but I feel that that's a step in the direction of basin-wide or watershed governance. Gail, I don't know if that really responds to your question about water markets, but I'm not exactly sure. I mean, I guess the only thing I would add to that is if you're allowing water rights of use to be transferred outside of a basin, that creates a functional problem, because when water is used within the basin, there's usually a significant amount of return flow that goes back into the surface water, or at least the groundwater, that's available for other use. If you just allow an open market where you can transfer any water right outside of a basin, hydrologically, then you don't get the return flow into the basin, which means there's less water in the basin. And I'm not quite sure what the solution to that is, but I think in California, it's why if you're going to make a change in a water right, the State Water Board needs to look at it, because it needs to look at whether that change outside of the basin might affect return flow and the availability of water for other users. So it sounds like there's not that check within the Chilean system right now. You can just do it and the impacts are what they are. Is that That's kind of my understanding.
In our case, we have a restriction that we do not have the infrastructure to transfer water from one basin to another. What we do have is between areas in a basin. So if you transfer from upstream to downstream, you have return flow issues. But that is an issue that hasn't been solved adequately, at least in the position of most of the specialists. I know we are almost in time, and Philip has a question to Natalia and Camila. Philip, if you want to ask the question.
Yes, thanks so much, Camilla, Natalia, and Paul, for your presentations. I really enjoyed them. I actually have a presentation that is for all the panelists, but I think probably geared more towards Paul. So in the context of a new Chilean constitution, some analysts have suggested that Chile should adopt public trust doctrine provisions in that constitution. And Paul, you mentioned how a public trust doctrine as a background principle of state law can blunt some of the takings obstacles that you brought up. And so I was hoping you could unpack that a little bit more and talk about how having a public trust provision could potentially decrease obstacles to adaptive water management and the transition away from overuse and overallocation to more sustainable management. And also if you could highlight what might be potential downsides of adopting such a provision. Thanks again.
Right. Sure. In terms of how a public trust theory might blunt a takings argument, I would refer you again to the U.S. Court of Claims opinion in the Klamath irrigation case, which was about I think 15 years ago now. But essentially in that decision, what they said is to evaluate whether we have a takings claim, we need to look at the underlying nature of the property right. And they said when it comes to water, that means the nature of that property right is defined by how state law defines that property right. So what they indicated without answering the question was if you have limits that affect your property right that circumscribe it by the public trust doctrine or by the reasonable use doctrine, that's the nature of the property right you have. And if you don't have a right to the unreasonable use of water and the government says your use is unreasonable, you don't get compensated for not unreasonably using water. And, the theory would be similar with the public trust doctrine. What I think might be a little trickier in the Chilean situation, though, is that in California, and the United States, we have a recognition of the public trust doctrine in some version that goes back, 125 years. So we could state that anyone who obtained a water right in California after, let's say, 1900, did so knowing that it was subject to the public trust doctrine. If you suddenly adopt a new provision of law that creates new rights, it would seem that the water rights holder might still be in a position to argue that, well, this right didn't exist when I got my water right. You've adopted a new provision of law that takes my property. It's a public trust one. So that, I guess what I'm pointing out is that the timing of it could have an effect on the takings argument. And if you take the position that we've always had these rights and we're just confirming them, that makes it more difficult to bring a takings claim. If you're very explicit that we're adopting a new provision, giving new authority to the government, they might still, notwithstanding that it's called the public trust, have a viable, at least under the U.S., I don't know the Chilean system, but under the U.S. law, that any new regulation that takes away your property rights, they don't care what name you give it. If you're taking it, you're taking it. But if it never existed because it's always been there, that's a different type of legal debate related to taking.
Thank you so much, Paul. Thank you also, Camila, Natalia. We are a little past schedule, and I would like to thank all of you who participated, your interaction with questions and comments in the chat and also in the Q&A box. A special thanks once again to Paul, Camila, and Natalia for their presentations and opening a lively debate and reflections that is the purpose of our conference. So thank you very much. I would like to remind everyone that we reconvene in 2 hours for our second session on future challenges of water law and water markets with a focus on environmental water management.
Thank you to all. It's been very interesting. Bye, Paul. Bye, Natalia.
Thank you very
much,
much.
Camila, Natalia.
A pleasure as
Nice
always.
to meet you, Paul, Philip, and
Maybe we
nice
can
to
continue the
see you,
discussion
Guillermo.
someday.
Bye.